Here at Charlie Crimebuster, we welcome comments, suggestions, opinions, and whether you agree or disagree with our view on a topic, we still want to hear from you. Reach out with a shout-out. Email Charlie at charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com. Or you can call or text us at 407-917-2211. That's 407-917-2211. And we'd like to thank our sponsor, PeacemakerNetwork.com, and also thank those of you who already support our podcast. Did you know that your donations not only help with this podcast, but also support the brave men and women, first responders, law enforcement, correction officers, security personnel, and our military? You too can donate, as well as become a monthly badge member. That's BADGE member by simply subscribing to PeacemakerNetwork.com. That's PeacemakerNetwork.com. And if you're a true crime junkie, we would like to encourage you to binge-cast by listening to our podcasts located on many of the popular podcast platforms. Simply search for Charlie Crimebuster, or you can ask your smart speaker to play Charlie Crimebuster. But since you're streaming us here on YouTube tonight, simply click on the subscribe button and you'll be notified each time we drop a new episode. So please do us that huge favor and press that subscribe button right now. And we thank you. The views and opinions expressed in this presentation are solely those of the individuals interviewed or participating and do not represent those of Charlie Crimebuster nor Peacemaker Network. All individuals described or mentioned in the presentation should be considered innocent until found guilty in a court of law. This presentation contains subject matter such as violence and graphic descriptions, which may not be suitable for all audiences. Listener and viewer discretion is advised.
The Karen Reed trial, some gotcha moments, James Buckland and I. We're going to talk about that on this episode of Charlie Crime Talk, where we talk about what we talked about in the last podcasts. Hey, James, how are you, my friend?
I'm doing much better, thank you, compared to last week.
You were a little hoarse last week, yeah, but
just a little bit.
A lot better, huh?
Oh yeah, much better.
Knocked it out, huh?
Knocked it right out.
Yeah. I just got in today. I was down in South Florida, down there near the Miami area, and drove back today to get back here in Central Florida where we do this episode.
All right.
And boy, I tell you what, a pretty time it is to be in Florida right now in this kind of springtime, you know?
It is. Cool evenings.
And it's unlike a spring, in other places, but it's still spring in Florida, you know?
That's right. Yeah. It is.
We have seasons down here. A lot of people don't think we do. We have seasons. They just last a couple of days, right?
Yeah. Yeah. That's so true.
Yeah. Well, we got a great program tonight. We got a lot of stuff to cover.
We do. Yeah, this is.
The trial's in the second week now. When I say first week, second week, what I'm talking about is after the jury was already seated.
Right.
And so we're talking tonight about the first real week of trial. And while we're talking about it, we're actually in the second week. And so we've got some really good stuff to talk about in our next podcast that we're going to be dropping Sunday into Monday, you know.
All right. Nice.
Yeah. But right now, let's talk about that first week and some of those gotcha moments.
Yeah, well, right off the bat, describing the first week of the actual trial, you talked about gotcha moments, but what is a gotcha moment?
Well, a gotcha moment, I like gotcha moments. It's kind of like when somebody's called out, like you say one thing, but it's proven another thing. Let's say that, you told your parents you were at school and somebody saw you and your friends down at the mall, you know. Mm-hmm. That's kind of a gotcha moment, right?
That's a gotcha moment.
A gotcha moment. You said something, but it's proven something else. But in these situations, they're very important because these gotcha moments may actually impress the jury in one way or the other. So it has a little more impact to it. Now, it's not really a smoking gun that we call smoking gun. When somebody finds out the smoking gun is what we baby boomers call the Perry Mason moment. You remember Perry Mason?
Yeah.
You know?
Oh, yeah.
He'd catch him on the stand, you know. So a gotcha moment's not quite a Perry Mason moment. It's not quite a smoking gun, but it is enough that it will impact the jury. And you get enough of those on one side or the other, it could even sway the jury.
That's true. Yeah, that's true. Well, tell us about the lawyers who gave the opening statements.
Well, like we said, I think last week, even in our crime talk, the real difference in this particular trial, and there's really several differences that we're finding as this trial develops. But one of the differences that we predicted, forecasted, was that Hank Brennan would do. He is the prosecutor. That he would do a much better job than the previous prosecutor. And Hank Brennan, by the way, actually worked as a defense lawyer and a prosecutor. And by the way, you can tell that that he has a lot of experience as a defense lawyer because all through his questioning, after you get through the opening statements where they're questioning the people on the direct, he many times will actually lead the witness. And in leading the witness, that's something that defense attorneys do, but prosecutors are not allowed to lead the witness. So
Hmm.
constantly you hear them object because he's leading the witness. And a
Yep.
lot of times he's leading the witness and Jackson doesn't even object, but you can really tell that he still has that defense side in him because he leads the witness over and over and over and over again.
Right.
One thing I found out about him that I think is pretty astonishing, he has won over 100 cases.
Wow.
So he is a very formidable attorney. One of his famous people that he represented was James Whitey Burglar. He was the Boston mob boss. And
Hmm.
he also serves as an adjunct professor at the Suffolk University Law School. So the real difference, I think, in this trial is that the prosecutor that they have now on the second trial I think is much better prepared to lead the prosecution.
Well, who went first, and how did that attorney do?
Well, the other attorney was Alan Jackson, of course, and
Hmm.
let me say a word or two about Alan Jackson because some people out there, you find I have found in listening and watching and reviewing this trial, it's kind of amazing that not only do you see people divided about the guilt or innocence of Karen Reed,
Hmm.
but you also see that the people are divided on what attorney they like over the other attorney. You
That's
know, you
true.
you you can
Yeah.
hear it in the replies of people. You can tell that they either get in one camp or the other. I like this attorney or the other attorney. Well, the other attorney is Alan Jackson. His career actually began at the Los Angeles District Attorney's Office. And he really too is one of those champions of justice, I call him. He was actually the assistant head deputy of the major crimes division. So what is interesting about it is that both of these guys have served on the other side.
Interesting.
That just like Hank Brennan had been a defense attorney, well, Alan Jackson had been a prosecutor, so they know both sides really well, which shows that both of these guys are just incredible attorneys to do this. Now, some of his high-profile cases was the trial of Philip Spector. He actually represented Kevin Stacey. He has basically been recognized as one of California's top 100 lawyers. So we have a California lawyer in Boston, Massachusetts,
Wow.
that's representing Karen Reed.
Wow.
So there's the lineup. One corner you got Hank Brennan, the other corner you have Alan Jackson, and boy, they are mixing it up there for sure.
Well, you mentioned something about the possible motive that was revealed in the opening statement. What was it? And is it important to the case?
Well, yes, sir, yes, it is. As when it really got off and got rolling in this particular trial, uh, the first person that does go with the two guys in the corner is the prosecutor, and the reason why the prosecutor goes first is that he has what the courts say is the burden of proof. They have to prove, the prosecution has to prove beyond a shadow of a doubt, as far as when I say beyond a shadow of a doubt, they got to prove it within reason that this person actually did the crime. In other words, the jury has to make that decision beyond any reasonable doubt. So the burden of proof by far is on the prosecution. The defense doesn't have to do that. In other words, if the defense and the defense is, as we have said, we all know today that the defense is going to be saying that this was a cover up, but the defense doesn't have to prove that someone else killed John O'Keefe. They just have to have enough reasonable doubt that Karen didn't do it. So the interesting thing, the prosecution not only goes first in the opening statement, but when it comes to the end, when they're doing the closing statements, James, the prosecution will go first then, but then the defense will go on the closing statement. But guess what? The prosecution gets to come back and do it again. So they get two whacks at the closing versus the defense getting one whack at the closing. And again, that is because the prosecution has a greater burden of proof to prove.
Right.
And that's the way these trials run. Now, the motive, the interesting thing about the motive is you do not have to prove a motive in order to get a conviction, but we are human beings, and we always like to know why, don't we?
We do.
We just say, well, why would a person do this?
Mm-hmm.
Why is it reasonable that this person would do this? And in this opening statement, you can tell right off the bat where Hank Brennan is going for the motive. And the motive to him was simply that there was trouble in paradise.
Mm-hmm.
In other words, there was a lot of trouble in this relationship of John O'Keefe and Karen Reed, and that they were fighting lots of times up to this, that they had some really, really shaky moments, and even that night that there were some shaky things going on that day, and so that she had motive to hit him because out of anger she did that. And of course also I'm sure he's going to combine the fact that she had been drinking that day as well.
Mm-hmm.
So now you also think about, well, if the defense is going to prove that someone else did, what would the motive for the defense be? Why would someone else do this? And of course, the motive that we're going to see from the defense is basically that this was a cover-up, that they were covering up for their cop friends, you
Right.
might say,
Right.
friends and family. They were covering up. So those are the two motives that we're seeing coming down the pike.
Well, what about the prosecution's expert witnesses?
Well, the prosecution expert witnesses, this is really, really interesting, I think. Um, in the opening statement, and we go back and we can bring this all the way back to the opening statement. We all remember, I think you remember, I know you and I remember, we talked about it during the other trial.
Mm-hmm.
The ARCA witnesses were just really spot on. This was the accident reconstruction group of guys, scientists who had degrees coming, they had more degrees than a thermometer,
Yeah.
I mean, they were really smart, sharp guys. They talked about physics and, emotion and all that sort of thing. And so they really, I think, were very, very credible in that first trial. Now, the judge had asked, because they did find out that after the trial, that there was some money that the defense had sent over for these experts, and so the prosecutor now has come back and said that that he doesn't they were considered non-biased in the first trial because they weren't hired by the defense in the first trial. They were actually hired by the federal government that was investigating the case.
Mm-hmm.
And so the judge wanted the archive people to bring forth in discovery all of the texts between the attorney Alan Jackson and the archive witnesses. And he did not bring all those texts before the trial started. In fact, they had Vador, where you have to bring a expert witness on, and he's questioned by the other attorney. And it come to find out that he had gotten rid of his phone, or he found a new phone. He couldn't capture all the text, but because the judge did not have the stuff that she wanted when this trial started, she actually would not allow Alan Jackson to even bring up the archive witnesses in the opening statement. So Jackson really could not in his opening, he could not refer to the archive people. And at that point last week when we dropped this podcast, we did not really know whether she would rule and allow the archive experts to actually testify.
Wow.
And this week, we always try to give people a little bonus, don't they, when they listen to us?
Right.
So something that we did not cover, the bonus is this: that even though the judge was very not pleased that the archive group did not provide for her the information that she had asked them to do, she felt like it would be a disservice to Karen Reed not to allow them to testify, but they are now allowed to testify in this trial. Now, the prosecutor is going to have some expert witnesses as well. He's going to have a neurosurgeon who's going to come. They're going to talk, according to the opening statement. They're going to talk. The neurosurgeon is going to talk about the injury to John's head, and that neurosurgeon says it's going to be like if he were to have been hit by the car and then he fell back on the hard, frozen ground and hit his head. And that's very important because they did not have that in the first trial.
Right.
The medical examiner basically said, James, that this was the cause of manner of death was undetermined. You know,
Yeah. Yeah.
the medical examiner did not say that this was a murder. Did not say it was. He said that the manner of death was undetermined.
Mm-hmm.
And then we also know that there was witnesses of the defense in the first trial that said, particularly with the archive people, that it was not consistent to being hit by a car. So now the prosecutor, he's going to have some experts this time, I think, that are going to be a lot sharper than the experts in the first trial. The first trial, basically, they depended on one trooper who came, and he did, he did come, and Trooper Paul was his name, and he had done some accident reconstruction, but he did not have the credibility and the credentials that the archive people did. But I do think this time we're going to see a battle of the experts. In fact, we already saw it this week when we talked about the cell phone, the
Mm-hmm.
temperature of the cell phone, and several things. So this is going to be a battle of the experts, and it's going to be interesting to see how it plays out.
Well, tell us about the first gotcha moment.
Well, the first gotcha moment, um, the prosecutor, Hank Hank Brennan, said that in his opening statement, and the opening statement, again, for those that are listening, the opening statement is not that what the attorney says in the opening statement is not evidence, but the attorney can say what he's going to prove in this trial and the things he's going to do. And one thing he said at the opening statement, Hank Brennan said, we're going to use Karen's own words against her. Now, people may be thinking, well, how can they do that? Because Karen doesn't have to testify.
Mm-hmm.
She's not required to get on the stand. She did not get on the stand in the first trial. I doubt seriously she'll get on the stand in this trial because that would allow them to, to cross-examine her.
Right.
But she has made statements in the media. She's had all kinds of interviews, and now the prosecutor is going to use her own words against her in those interviews. And right in this first trial, one of the things that he did do, and he did bring out in the trial, is in one of her interviews, she said these words. She said, she said, I didn't think I hit him. I might have clipped him, but he did not look mortally wounded as he left and walked into the house. So, by her own statement now, she said in that one interview, I didn't think I hit him. I may have clipped him. And so,
Hmm.
that's going to be, I think that's a gotcha moment. Uh,
Yeah.
she, she, she won't get on the stand and say that, but she said that in her, in her own interviews.
So, what was our crazy crook story about? As we take a small break here.
It's a crazy crook story. Well, hey, James, it happened in Florida, buddy.
Another Florida guy.
Yeah, another Florida man. Um, I'm glad we live in Florida because we don't run out of the stories down here,
That's
right?
right. Got
Uh,
plenty. Got plenty.
oh yeah, this guy was definitely drinking and driving. The way he was handling his car, his vehicle, showed to the officers that the good possibility he was intoxicated. So he did not pull over, and so they got in a pursuit. And pursuits can be some really crazy times. They can be dangerous, and they can be crazy times. But the crazy thing about this particular pursuit was while he's running from the police, you know how they get out there and they're really trying to throw the stop sticks out and all that
Yep.
sort of thing.
Yep.
While he was driving by, he slowed down and offered the officer on the side of the road a drink. So he's going out and he puts his drink out the window and says, hey, you want this, to one of the officers, and he just keeps on going. And finally,
Uh,
they do run him down, and he gets out. And the first thing he says, "Hey, you all had fun, didn't you? Wasn't this fun? Didn't we have fun? You know, didn't we have fun?" And then he wouldn't stop. He just walked. You know, he was surrounded by these officers, and so he just walks right through them. You know, and so eventually they have to tase him to get him down on the ground.
oh my
So
word.
this crazy crook who thought it would be the right thing to do to offer one of the officers a drink while he was driving and running from the police, that was indeed our crazy crook of the week.
Crazy crook of the week.
Yeah, we just don't run out of those guys here in Florida.
That's certain. We most certainly do not. Tell us about the defense opening statement in the Karen Reed case.
Well, the defense opening statement. Now, remember, like we said, you know, his hands was kind of tied because he could not. I think I don't know about you. I think the most impressive part of the defense was the Archive witnesses
Yeah,
that
Dr.
came to
Reed and Dr.
testify.
Rensler. Yeah.
Yeah,
Hmm.
both of them. I think that was the most impressive
Yeah.
part of the defense, and that's my opinion, and I think you agree with me. And there were a lot of other good things for the defense, but remember now, his hands are tied, so in his opening statement, he can't even refer to the Archive witnesses at this point,
Mm,
and the jury's never heard of the Archive witnesses.
right.
So his hands was tied, but he's still, man, just like Hank, he came out fighting. You know, the first very thing he said the investigation was corrupted from the very start. So he's really punching down on how what a sloppy investigation was done by the police, and so he's bringing that into his opening statement.
Hmm.
He basically says, you know, that John O'Keefe did not die from hypothermia, but that he was killed somewhere and moved.
Hmm.
One of the things he said throughout his statement was that the entire case, he said, is riddled with doubt. He
Right.
said, "You talk about doubt." He said, "Doubt's all over the place." And then we knew that he would certainly refer to Michael Proctor. You know, that was the
Oh,
trooper
yeah.
that got fired and the guy who said all those terrible things about the person he was supposed to be investigating, and
Right.
the guy who just, you know, really, really tanked this case, in my opinion. He basically said that Proctor, and this is a really a colorful words. He said he was a cancer that spread all over the case. And then he pointed home again. He said, "We're going to prove to you there was no collision. There was no collision. Therefore, if there was no collision, there should be no charge." And
Right.
so we know that the defense is going to really hit this, you know, hit the investigation, and the problem of this whole case is that the police in this particular situation, because they did not follow proper standards in investigating this case, they really have handed the defense a lot of ammunition to use in this trial.
Yeah, that's
And they
true.
did in the first trial as well, you know.
Right. Well, one of the things that was different about this trial was that John's mother actually testified. How'd that go over?
You know, Peggy did testify, and you know, you can imagine this, James. Now, this is a lady that lost her son that day. You know, a decorated cop, a fine, outstanding young man in the community. You know that he was the apple of her eye, no doubt about that.
Hmm.
But keep in mind, before she even got to this point, her own daughter, you know, was killed,
Right.
died rather,
Right.
and then her son-in-law, who was married to her daughter, he died of a heart attack right
Right.
after his wife died.
Right. Couple of
And the two
months.
children were there by themselves, you know, and John adopted them.
Hmm.
And so you can imagine here's a lady who's that's three big ones. I mean, that eating one of those is big enough to really hit you hard.
Yeah.
And she's up before the jury, and you can imagine the jury is glued to her testimony, and everybody feels for her. But you know, one thing I really thought that was really I thought I admired it a great deal is you talk about somebody who's really good at cross examination. That's Alan Jackson. And you know, you always I was fearful myself that he would get up and you know really tear into her because she is pretty well siding against Karen Reed. But instead of that, he just got up and he said, "Ma'am, you have our condolences," and he said, "No questions," you know.
Wow.
And I think that was, and I don't think he did it just for the jury's sake to impress the jury. I think he really felt what all of us felt in that courtroom. There's nothing but empathy, sympathy for this lady who's gone through so much.
Right, right. And
And,
it
and
could,
again, and again, this brings us to the other thing I was saying, James, is that one of the things that the attorney's doing, Hank Brennan, is in this time he's doing much more to humanize John O'Keefe.
right.
Staying away from the cop part, but just really put him before the jury. That hey, he's a son of someone. He's
Hmm.
someone who's loved. He was a guardian of these children. And I'm sure that bringing Peggy to the stand helped him to humanize her in this
Right,
situation
right.
rather than and he probably will stay away from the police thing because the police thing kind of plays right into the hands of the defense.
Sure, sure it does. Well, tell us about day 3 of the first week.
Well, the first couple of days we had the opening statements, some witnesses, this sort of thing. Day three, you could pretty well summarize day three very easily. It was smear Karen Reed day.
Hmm.
I mean,
Hmm.
that's
Hmm.
the day they read those terrible texts that she had said some terrible things to John O'Keefe.
Yep.
They talked about her drinking. They talked about this. It was basically smear the defendant day, and they did that pretty well throughout the entire day. And we all know that she was very emotional. That she was very upset that night. She said some really terrible things. I hate you, blah blah blah.
Yep.
But the kind of things that people say when they get in spats. And at this point, she thought, according to the defense, she thought that John had just stayed at that party and didn't come home, and maybe was with someone else and all that. So they really brought that out on the third day.
They did. What about the field trip and the neighbor's interview?
Yeah, on the next day, they took the jury, as they often do sometimes, to the scene.
Hmm.
And so they took them out there to the theme. They also had brought Karen Reed's car out there. This is 94 Fairview, so that people could see that yard where John O'Keefe was found dead, so that they could see the house that they're talking about there. And it wasn't. I didn't think there were any gotcha moments there. I don't know that really does anything for the prosecution or the defense. Maybe it might even though the prosecution likes to do these kind of things, it might even play into the hands of the defense because you can see how close John O'Keefe's body was to the bedroom, of Albert, the Albert's bedroom there, and so they were talking there, and the journalists and the reporters, they could not talk to the jury. They could not really get any story there. So there were, as you can imagine, you have all this jury come out and you have all these police cars, and if you're in the neighborhood, you're probably going to come out and look what's going on down around the street, what's going on next door. And so one of the neighbors came out and said, "Well, we're going to interview one of the neighbors." And one of the neighbors said, he said, "What was interesting to me," and this is the neighbor on television.
Right.
He's saying, "Well," he said, keep in mind, in fact, the reporter said, did you see a snowplow come down the road?" Because one of the things in the first trial, if you remember, is that the defense said there was a snowplow driver who came at 2:30 in the morning, and
Right.
he said, "I did not see John O'Keefe's body in that yard." That's what he said. He said, "I looked over there. I did not see a body," which really plays for the defense.
Right.
And so he said, "Yeah," he said, "the snowplow guy said he didn't see it." And he said, "Keep in mind, they had like several people in that house who left that house that morning, and none of those people said they saw that there was a body on the line, on the lawn."
Exactly. Yep.
And then he said, he said, Alberts, he said, Mr. Albert said, then he turned around and he refloored the basement, and the defense alluded to the fact that they think that John O'Keefe went downstairs and upstairs, so they thought maybe he was killed in the basement.
Right.
And so Albert refloors his basement. He turns around and gets rid of his phone before the authorities can get to his phone to see what's on his phone. he turns around and they give their dog away, and the dog, of course, is very central in this case because they say the wounds on his arm is more akin to dog bites, is what the defense says. He
Right.
gets rid of the dog. He gets rid of his house. So basically, this neighbor says, that there's a consciousness of guilt there. Now, to be sure, the jury didn't hear this neighbor, but I guarantee you every one of those points will be brought home with the defense again in this case, don't you think?
Absolutely. Absolutely.
I mean, you have to wonder, uh, even though, I'm probably leaning myself in this case more to the fact that I think she accidentally hit him, but you still have to wonder about the actions of these people.
Yeah.
While these actions in itself does not prove that, that they killed him, they're certainly suspicious, do you not think?
Well, there's enough doubt there.
I
There's
mean,
enough doubt being introduced to make you
what,
question.
why would he get rid of his phone?
Yeah.
Why would he get rid of the dog?
Why would you floor your basement?
Yeah,
Refloor your basement. Yeah.
yeah. Now, there are going to be answers to that. They refloored the basement because they're going to sell the house. Got rid of the dog. According to him, the dog bit somebody else or bit another dog or this sort of thing. Hey, another thing the neighbor said that dog had bit plenty of people around there, not just
And there's
not
more
what the
proof.
fence. Yeah,
Yeah.
yeah. So yeah, that's what happened during the field day. I thought there wasn't much happening in the field day, but I thought what the neighbor said is really, really interesting.
Well, tell us about the other gotcha moment.
Well, the other gotcha moment. Now, the first gotcha moment, as we know, was basically for the prosecution. This was
Right.
for the defense.
Right.
One of her friends, Carrie, she came to the stand, and she had actually talked about that text, that infamous text that the prosecution says started at 6 something in the morning, and the defense says no, it was 2:37 in the morning. She said to the grand jury, Carrie Roberts said to the grand jury, no. Jan McKay did that text, "How's long to die in the snow," or in the code. She did that text at 6, not 2:30, like the defense said. But when Alan Jackson cross-examined her, he really got her to admit that that was not true. That
Wow.
what she told the grand jury was not true. She did not see her make that text. And I thought was even more outstanding in this trial was when she admitted that on the stand. No, I lied to the grand jury. I did not see McKay do that text at 6 in the morning. The judge even looked at her and said when they were going back and forth with the cross examination, "Did you lie? Did you lie?"
Yeah.
And she had to admit, no, I did not tell the truth of that part of my statement. And
Wow.
that was certainly a gotcha moment, don't you think?
Oh, absolutely. Yeah.
So, you have one gotcha moment in the first week for the prosecution and one gotcha moment for the defense. So I would say, as far as what the trial stood at that first week, at the end of the first week, I would kind of say it's kind of a tie. I think both the prosecution and the defense did a pretty good job and kind of a tie. But when you think about a tie, I think a tie in any trial is probably probably reasonable doubt.
Absolutely.
You know,
Absolutely. Yeah.
yeah. So we got some really exciting things this week, though, and I can't wait for our next podcast.
I can't wait for it either.
Today when you and I are recording this, the court is dark. They're not having any activity, but tomorrow the jury be back and we'll be right on top of it. And by this weekend, we'll be able to give people a summary of the second week that we're just in right now.
All right. I look forward to it. Well, thank you, Charlie.
All right. Well, thank you, ladies and gentlemen, and boys and girls, and everybody out there. We appreciate you being a part of our program tonight. Stay tuned. We'll be here this weekend and be dropping the next episode of Charlie Crimebuster, and we'll be talking about what happened during this week at the trial of Karen Reed, the second trial of Karen Reed. So until next time, this is Charlie Crimebuster reminding you, stay safe, stay alert. Yep. For the life you save, it could be your very own.
You have been listening to Charlie Crimebuster. You can find additional podcasts at charliecrimebuster.com. You can also support our first responders, military, and law enforcement communities at peacemakernetwork.com, or subscribe to our YouTube channel using tag @CharlieCrimebuster. Even visit our Facebook page, facebook.com/CharlieCrimebuster. Or if you would like to make suggestions for future podcasts, please send your ideas to charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com. Thank you for joining us today, and we hope that you will join us next week for another exciting crime story with Charlie Crimebuster.